Good morning and welcome everyone. Welcome everyone to the firing line. I'm Cole Ranger, Head of Training here at CEO and CEO Academy. And today we'll be diving into one of the hottest discussions in South African labor law right now, the new draft code of good practice on dismissal. Is it a game changer, legal minefield? Will it make dismissals easier, harder, or maybe just more confusing? To break it down, I'm joined by two of our top legal minds here in South Africa, Jean-Ray Kruger and Daniel van der Merwe. They'll be tackling the big changes, any controversies, and of course, your burning questions. We're live on LinkedIn, Facebook, and YouTube, so please drop your comments and let's get the conversation started. Jean-Ray, Daniel, welcome. Let's dive right in. What are the most significant? Yeah, there we go. Can you guys are just fine. What are the most significant changes for the new draft code? Jean-Ray, maybe you want to weigh in on this.
Yeah, thanks, Cole. Interesting times. I had to open with that you're saying this is the burning question. I think the budget speech or the lack of a budget speech yesterday and the 2% VAT increase proposal is probably on everybody's mind. But nevertheless, obviously, even if there are VAT changes, it's going to filter down to everyone and employees alike. So obviously, we need to look at the code of good practice, or what the code of good practice that they are proposing, and the elements that they're trying to address. So, yeah, what are the big changes? I think, let me initially say, I think I'm very happy with how it has been drafted. It gives a lot of clarity. It almost feels like it is finally legislation that is drafted by an attorney or someone that does internal labor, for a living. So, the big changes are, I think it's bringing a lot more clarity than your original code of good practice would have had. It specifically mentions small businesses. It doesn't identify what it means by small businesses, but we can assume, and if we have a look at the history of small businesses and certain exclusions, we're probably talking about micro employers, 10 and under. So, they're trying to give those guys a little bit more protection. They're trying to make the process a little bit less formal. What will the effect be of that, or bringing down the formality? Will the CCMA actually follow suit? And will you be able to argue these things when you get to CCMA disputes? So we'll get into the nitty-gritties, but it looks specifically at dismissals or terminations, so either dismissals for misconduct, either incapacity, poor work performance, and it even goes into, and it acknowledges the word retrenchment. Finally, it has always been the buzzword, but they've taken the dismissal for operational requirements and called it retrenchment. So those are the major changes, and I'm looking forward to it. I'll invite everyone. Obviously, we're having this discussion today because we need to submit our contributions to the Minister of Labour as well, and we obviously want to push forward our members' opinions on it. So I invite questions. I'm sure Daniel as well, and we invite everybody's input after this. So yeah, let's get into it.
Great stuff. Thanks, Jean-Ray. I really appreciate that. Yeah, for all our viewers just tuning in, even if it's after the fact, this recording will be made available across our social platforms. So if you don't have time to tune in now, no fret, you can watch it after. Post your comments in the comment section across the various platforms, whichever one you're tuning into. I will address them even if it is after the fact, and hopefully we can use those comments to put forward to the Minister of Employment and Labour. Daniel, Jean-Ray mentioned the impact of these changes, or how these changes will affect employers and employees. Maybe we can break it down to a bit of a practical, practical sense. How will they affect them?
Thanks, Cole. Morning, everyone. So I think from our point of view as well, upon a first reading of the draft, I was quite excited because it's a development that I think's been a long time coming, and it's something that's desperately needed. I think the fact that it mentions small business, it really looks at small business and the challenges they face as well. It's something that's really a positive step, and I think the way that's going to then impact in the workplace, or how it's practically going to play itself out, is this idea of a less formalistic, especially when we look at a small business kind of lens, or we look at it through that lens. I think Jean-Ray touched on it. How is the commissioner going to deal with this idea of me adopting a less formalistic approach? I'm not so sure yet, because I know, what happens here and what happens somewhere else sometimes differs. But for me, that's quite exciting. I think it also, in as much as it's a positive move for employers, especially small employers, this less formalistic idea, it can also be a positive to employees. I mean, if one thinks about a disciplinary process, for instance, it can be quite an daunting or intimidating process for an employee that's maybe facing this. So something like a less formalistic approach in a practical term and how we apply this code, I think could have joint benefits on both sides, So I know there's a few things in the code, we're not touching on it yet, but something like the industrial action and dismissals around there. For me personally, someone who operates in the collective bargaining sphere, there's one or two red flags there and how that practically might play out. But
we'll get to those red flags.
We'll get there, and that's why I say we'll get there eventually. But, practically, this idea of less formalistic, I definitely think is a positive move in the right direction.
Just for reference, maybe, Jean-Ray, for our viewers tuning in who aren't really sure what Schedule 8 is, would you mind just explaining it to anyone new to it? I know Schedule 8, forms part of the back of the LRA, but not everyone really knows about it and why it's important. Maybe you could just quickly address that for our viewers.
Yeah, look, Schedule 8 aims to obviously regulate firstly, internal discipline, how it is dealt with, and ultimately, what is the fair procedure and fair reason to terminate an employee. So it's been part of the LRA for many a year, and it has, in its current form, left a lot of interpretation issues and a lot of scenarios where you could take advantage of the gray areas, or you could actually fall short when being assessed by a commissioner in regards to your process, because it's my fare and your fare is not always the same. There's always inherent biases and backgrounds, and the interpretation of certain things does become a little bit difficult. And I think, and we don't want to now say it for the third time in a row, I think the problem is going to come with the less legalistic approach that this new code is proposing as to when can I, one, who's a small business, and when can I be less formalistic, and can I at all be less formalistic when I am terminating an employee? I think the broader, less formalistic approach will probably be more effective in regards to warnings, internal discipline, and running through that progressive discipline. But in my personal opinion, and the experience I've had over the years at the CCMA, and as well as the pressure the commissioners are under to try and get disputes resolved, I've failed to see how a less formalistic approach when terminating an employee is really going to fly at the CCMA. So Schedule 8 tries to regulate that, and hopefully, with a bit more clarity and a bit more leeway, that should smoothen the process internally prior to dismissal. But I have strong reservations about a less formalistic approach when actually terminating an employee.
Schedule 8 is in essence a guideline for both employers, employees, and obviously the commissioners across the bargaining councils and the CCMA, even the labor court judges. They look at it as a point of reference when checking who did or who followed the correct procedure. Jean-Ray, you mentioned gray areas now. My next question was going to be regarding these gray areas. Do these amendments or proposed amendments provide more clarity or create more gray areas compared to the previous code?
Look, I think the previous code was a little bit too vague. I think they have gone here and tried to address maybe a lot of the vague points or a lot of the gray areas that they historically had. So I do think it's a move in the right direction. Unfortunately, internal labor remains I wouldn't say volatile, but I mean, it's a very personal relationship. I mean, people build, employers build trust with employees over years. And the same with employees versus employers. We always say the act and the strictness of it, it's built for the people who break the rules, and not for the people who follow the rules. Because, we represent many an employer, and the bulk of employers and employees have very good relationships. But this is something to bring it together, to give you a little bit more guidelines. They have added things. We're going to get into the procedural and substantive fairness now. They have added a few more layers just to consider. I think it should eliminate more gray areas? Will it eliminate all the gray areas? I think we've already touched on that. I don't think so, but I don't think there is very clear legislation that ever will be able to create such a personal relationship that the employment relationship ultimately is. It's a normal relationship. Nobody writes the book. Nobody writes the book on how to make sure that a relationship stays healthy. That depends on the parties as well. But the code as it is proposed, I think it does provide more clarity. It eliminates a little bit more gray areas than we would have sat with the previous code.
Great. Daniel, any advice? You mentioned small businesses in your previous answer. For being a small business in South Africa, were they sort of left behind in the previous code? Was it more focused on large scale businesses? And how will these small businesses have to adapt to this new code?
Yeah, thanks, Carl. I think, not so necessarily left behind. I think what the current code, kind of imposes on employers, whether big or small, is quite a formalistic, quite a procedural approach. And I mean, especially, I think Jandre mentioned just now, like a micro business or someone who maybe employs less than 10. I mean, your focus at the end of the day is growing that business, being profitable, being sustainable. When you're faced with a disciplinary challenge, for instance, and you look at the current guise of the code, how it's interpreted at the CCMA, how it's kind of practiced, the issuing of a notice, the minimum time frame kind of between the notice and the hearing, and a potential postponement and things like that, you can imagine the time burden and the administrative burden that puts on a small business, and how much that takes away from them, being productive, being operational, and trying to sustain that business. So yeah, I think there's definitely that element at play there.
100%.
So I wouldn't say the code necessarily was a burden. Well, the current code helps so much. I think it's more of a burden, and I think the new one definitely looks at trying to take away that burden a little bit for small business.
Making it more inclusive. Yeah, I think, being
inclusive,
100%. Being for the voice of employers, at CEO, we want to cater and we look after from the small businesses to the JSE listed companies across the board. Sorry, I see we do have a comment here, which I will read out to you guys over here, from Tsidi. In my view, a less formalistic approach would be more effective for implementing corrective measures. However, I found it challenging to see how this approach would apply in cases of dismissal. Perhaps a less formalistic approach should be restricted solely to corrective discipline. Comments?
Yeah, I think that's what we just touched on. I believe it should be used, and it should be less formalistic when you're trying to progressively discipline an employee and to try and correct behavior. So I think 100% the viewer that's commented there, 100%. I agree as well with the fact that it should be a little bit more formalistic in regards to the termination. But that's just what Daniel touched on now. If we're looking at small businesses and you're looking at a very formalistic approach to terminate, let's say I've got 3 employees and I have to go through an extremely formalistic process of disciplinary hearing and all of that. I'm taking one, let's say it's an owner and 3 employees. I'm taking an owner and an employee out of production. So solely 50% of my organization is enthralled in disciplinary action, which means I can't, that small business is just not going to move forward. Obviously, the larger businesses have more capacity to deal with that. But yeah, no, I agree in totality with the comment.
Thank you for the comment. Please keep the comments coming, guys. We will be submitting these comments to the Minister of Employment and Labour on behalf of our CEO members and the public at large. So please keep them coming. We encourage it. All right, guys, moving on to the procedure. So we've now touched on the less formalistic approach as well, the comment that we just had to dissect there. Does it benefit or harm employees? Looking at the flip side of the coin. Daniel,
I think I'll take this one. Can I take this one?
Yeah, no, please. I'm shooting to both of you here.
Okay. Look, I think the less formalistic approach, if we look at the way the new or the draft code is worded, it talks about this encouragement of dialogue, and in as much as encouragement of dialogue, it can be a good thing. It can also be a bad thing in the sense of where do you draw the line between discipline and, kind of going, okay, yeah, you will will not let this happen again kind of thing, and I think it's also that whole thing of the progressive discipline and all that involved as well. But the less formalistic approach, like I mentioned, I think it's situational, it's kind of dependent, if we're looking at maybe minor infringements or minor things like that, that less formalistic open dialogue kind of thing can be used quite constructively, in my opinion, to resolve issues and to avoid issues down the line or further disciplinary issues. But I think I think you mentioned it was TD, when it comes to more serious things, when it comes to bigger organizations, I don't think it will have such a positive effect. And I think we've also seen at the CCMA as well, this idea of, even though we maybe have a less formalistic approach, when it comes to finally pulling the proverbial trigger at the end of the day and effecting a dismissal, a lot of the times you're asked, okay, but where's the history of you disciplining, or where's the history of you, kind of correcting the behavior? And I don't know if it's really going to fly to say that, oh, but we've had so many discussions on this date and that date and the next date, because let's be honest, we've all been in that boat, and it's very difficult to kind of convey that in that particular moment. So in effect, I think it must be used situationally. If this draft code is then put through, and that's the kind of ideology that it espouses, I think it's purely situational. And like, if we're looking at a smaller business, maybe that's beneficial, but in more serious situations, I don't think so much.
I think in practical terms of how the CCMA or commissioner, and I'm putting on the commissioner hat here, when I look at a less formalistic approach, you're dealing with someone who's lost their job, and now there are certain requirements that need to be in place procedurally in order to lead to that dismissal being fair. Now, with this genuine dialogue, that the code mentions, is it enough to ensure fairness? I don't know. I mean, it plays both ways, but in my view, and this is just my 2 cents, maybe there should be a distinction between less serious offenses where there's progressive discipline followed through that less formalistic approach, that genuine discussion, versus your more serious offenses, which are more formalistic in nature. I mean, that is the whole purpose of having rules in the first place. The more stringent or strict the rule is, the more clarity it provides, that this is the line that I cannot cross, and if I do, there will be consequences. With this less formalistic approach, that line is very blurred, because when is it a genuine dialogue? You correcting me, for example, for negligence, just that conversation, does that count towards the disciplinary hearing? Have I been given my fair opportunity to state my case? I don't know. All right.
Well,
talking
Cole,
about,
sorry, man, just to jump in there, I think, and I think we've now canvassed the fact that you should probably have more formalistic when terminating. But I'd like to see how the CCMA and the commissioners interpret this in the unfair labor practice environment. If you're seeing more and more warnings being referred as well. And as Daniel said, you get to the CCMA and they're like, okay, but where's the hearing? Where the documents, where's the minutes? So I think that should also be quite interesting to see how the CCMA would interpret something, the dialogue, if you will.
No, 100%. Moving on to inconsistencies in disciplinary action. Should past leniency by an employer prevent future dismissals? Daniel?
Yeah, look, I think a big question, and I know it's always one of those that kind of pops up at the CCMA on the day of the actual arbitration or something. It's never raised prior, but then it's raised at the actual arbitration. Look, I think what the code also tries to do with the draft code is, you mentioned it in the beginning, it's but a guideline. Obviously, each situation is unique. And while consistency is obviously something that has to be kept in mind at all stages, consistency is also something that can sometimes apply to a situational aspect. We can't just paint the same brush on every situation. So consistency is obviously important, but it needs to be looked at in each situation and judged on its own merits, because one might have done something the same and someone else might do the exact same thing, but there might be a different situation around it or circumstances around it. So obviously it is important, but it needs to be looked at in each unique situation.
I think something that the public at large, if you're dealing with an attorney and they say, it depends on the merits and the facts of the matter. And it's always that sort of over-encompassing caveat that's, we're talking about this specifically, but it depends on the facts. And it really does. It really does come down to the discretion of that particular offense and that particular circumstance of how it is applied. And sometimes it is a 50-50 call on the employer side or on the commissioner side. Jean-Andre, I had the... Yes.
Just to add there, I think if you go and look at the code because now we have a specific paragraph on consistency. They mention there that it remains a question as to, has the relationship become intolerable? Is there a possibility of a future relationship, which is a big element. But consistency has always been there. You need to treat employees the same. And we always advise, if there are past inconsistencies, be proactive, correct it with a memo. Say, listen, this has come to our attention. It's been inconsistently dealt with. We're moving forward and we're going to deal with it in this specific way. But I welcome the fact that the code says, look, you still have to look at it. And has this trust relationship broken down? And can that circumvent certain inconsistencies that might have arose? Because it's the same. It's if you have a base level blue collar worker doing something versus a senior manager doing something, two different boats. You're not going to be able to sail together.
No, the duty of care definitely plays a role there. There's a much stringent, responsibility and onus on, standard that they're held to for someone in management versus maybe a general worker. So you have to apply that consistently according to where they are, their type, their position, their responsibilities, and so forth. Looking at retrenchments and operational crimes specifically, these now have been expanded upon in the new code. Are employers more restricted than they were previously? Section 189 was pretty, well laid out as it was for the procedure. How does this now complement Schedule 8?
Let me take that one, Daniel. Look, I think it's an extension of how the internal process plays out. It still speaks about consensus. We're going to try and reach consensus. So I strongly believe that this is merely an incorporation of 189 into the Code of Good Practice to give guidance. I don't think it's something new. I don't think anybody's shocked at that process as how it's laid out. If you've dealt with an internal retrenchment, this is pretty much how you would advise an employer or how you would deal with it to go through it. So I don't really see anything that's a eureka moment for me in that section. I think it's an extension of 189, and how to deal with those processes. You're still going to be bound by 189 and 189A as well. And it briefly addresses 189A, I think, in one paragraph of it. So nothing that surprises me. I think the process remains. I must say I expected the severance amount to climb a little bit if you heard the murmurs prior to them actually publishing it. Another 2% anyway. So I must say I think it just clarifies the process very nicely. I think you can take that as a how-to guide, and you're going to implement it on those steps. Ultimately, consensus seeking, you need to try and avoid it. You need to try and minimize the effects. So the essence of retrenchment in the process remains. What I do welcome is the fact that you'll be able to take the code now and go to the commissioner and say, well, listen, here, I've done these things. It should be fair. How long it will take? Most of the retrenchment jurisdiction still lies with the Labour Court. I was also expecting a little bit to the CCMA scope to be broadened a little bit, but we must see as the legislation changes and as the CCMA rules maybe adapt. So this might be the one thing I am seeing, and again, purely opinion. I think this is guiding into a scenario where the jurisdiction of the CCMA is going to get a little bit broader in interpreting fairness of retrenchments. But again, only my opinion.
Yeah. No, it'll be interesting to see what does develop through the case law and also the case load of the CCMA. I mean, the Labour Court is over encumbered with matters at the moment, with set downs coming, a few years up and down. Sorry, apologies. I'm just checking over here. We've got a message from LinkedIn. Okay, here we go. Comment. When submissions close in March 2025, the draft code goes back to NEDLAC. Is that then gazetted, or must it go through the bill form before Parliament, together with other Labour law amendments? Comments?
Yeah, I think as far as I understand, this one needs to go back to Parliament, and then once it's approved, gets gazetted, Carl.
100%. Okay, I hope that answers your question. If you have any follow-ups, please drop them in the comments. All right, moving on. Jean-Ray, you mentioned now the consultation process of specific retrenchments related to operational requirements. Does this, how can I say this, formalized, structured consultation process, does it protect employees more and slow down the business decisions at the end of the day? Or do you think it actually creates a more clarity in speeding that process up?
Yeah, look, I think it's going to cut down to, yes, I don't want to use the word, but let's call it punitive retrenchments. I think it's going to cut down on that, where, again, legislation's for the guys who break the rules, but so it's not something we see a lot, but it's going to cut down that. It's going to go back to that dialogue element that Daniel was already touching on prior. So yes, it is going to place a bit more, I think, the onus on the employer to truly negotiate and truly be transparent. But yeah, I think it's still going to run the normal process in regards to that. Where there's genuine need for a retrenchment, either financially, structurally, or operationally, it's going to have to move as quickly as possible to ensure longevity of the business and protection of the other employees' rights. But I think it will place a little bit more onus on employers to be transparent during the process and say, well, listen, this is the scenario we sit in. So I strongly believe the once-off consultation is probably something of the past. You'll probably have to go into at least one or two consultations to give employees the opportunity to be able to respond. But I also do think, if you look at the how the media is currently and how information is being shared, I mean, there's various individuals on TikTok giving Labour advice. I will always advise to double check those, as I see, people are very opinionated, but that information is going to be out there. So you're going to have to give individuals an opportunity to respond and, be thoroughly informed of why we're sitting in this retrenchment process.
Please consult your Labour specialist or Labour advisor before taking ChatGPT for its word. You've heard it here first, folks. Disclaimer. All right, guys. So on the consultation process now, what is the current stance on companies being required to re-employ retrenched employees, and does that now change in the new code?
Okay, let me take that. Okay. Daniel, no, you grab it.
Okay. So look, I think the big thing is obviously in the new code, it talks about the subject to the consultation process, employers may need to then rehire. I think the key there is that whole subject to the consultation. There's also, I think it's 1862B, if I'm not mistaken, that talks about the failure to hire employees consequent to a collective agreement, or once they've been retrenched, or whatever that the case might be there. But I think that's also, it depends on the unique situation of that particular employer at the time. It talks about employers needing to rehire with comparable skills and qualifications as well. So, I mean, for instance, one can imagine if there's a retrenchment that takes place and 6 months later, suddenly that vacancy becomes available again, or the opportunity, whatever label you want to give to it. Why should the employer not maybe make or reach out to those employees again and re-employ? I think especially in our job market, everyone knows it's difficult out there. It's difficult to find employment. The unemployment rate is high. So, yeah, I don't think it necessarily makes it a prerequisite, but I think it's obviously something that's obviously coming out of the consultation process itself, and the agreement or the consultations that take place and what gets discussed there and what the outcome of that is. will determine that. But I don't necessarily think it's a bad thing. I think obviously it just needs to have certain limits maybe imposed on it as well, something like time frames and things like that as well.
Yeah. I know the outcome of most consultations through experience, the employer agrees that should there be vacancies in those positions within the next 12 months, that they then are legally obligated to reach out to those employed or those retrenched employees. I mean, that also safeguards employees from malicious retrenchment procedures that are done for maybe the wrong reasons, just to get rid of a bunch of employees. So I do think it straightens it out there a bit as well.
Yeah, I think it also boils down to the crux of the retrenchment, as they're now actually labeling it, is it's being a no-fault dismissal. So that I think covers employers and employees as well in the long run.
All right, moving on to incapacity, incompatibility, performance issues. I kind of like this one in the code because, the comments that I received leading up to this event in particular regarding incompatibility, people didn't realize that was a thing. If you don't fit in, you can get out. So when we talk about a cultural fit or maybe a conflict with colleagues, I'm talking about maybe employees that have just been onboarded and new to the organization. Is this now a recognized form of incapacity? Was it always? And how does Schedule 8 deal with that? Is it fair? Slippery slope? John?
Yeah, look, it's been around for a while. This incompatibility, incapacity. It's it's you speak about it in the dark corners of the CCMI halls and stuff like that. And I think amongst a lot of labor law experts, they have identified that it should probably be a thing. Especially, I mean, if you look at the world currently and the cultural fits and harmony at work and all the effort and money and the training that goes into creating company culture, making sure that there's proper mental health. It's a natural progression, I think, from that, isn't it? That we go how it is implemented. I wonder. I would love to see how this runs through to the Labour Court the first time. I think you're really going to have to prove that, listen, this individual is creating a toxic work environment. You'll have to go very nicely and have a look at your HR books and your psychology books as to what that definition is. Is there a specific group that's ganging up? Is there subject to bullying? So all these new world elements are going to fall into that type of process. So interesting. I think it's bold to recognize it, but I think a natural progression as to how the world is working and how we're moving. And I don't want to jump into the next one, but if you have a look at the expansion of this entire probation situation as well, making that a lot more solid, and obviously from the start saying, listen, it shouldn't be used to obviously circumnavigate certain other elements, but it says, listen, use this part to see if, one, are they performance-wise ready for this job, and two, are they a cultural fit for the organization? Because as I said, a lot of time and money is being invested in making sure, because the world's tough out there. It's and Daniel said it previously. It's the unemployment rate's high. The interest rate hasn't come down as we all thought after it's been tough for a while. So we need to create safe mental health spaces for employees. And if you then look at the probation as well and how this code clearly says, listen, yes, there has to be procedure during probation, and you have to ultimately, I think paragraph 18 of it, or section 18 says the decision not to confirm an appointment. That says, listen, you don't have to be that formalistic. And I love it, and I don't know how many people would have picked it up, but under that section 18 there's a nice little footnote there that states that, listen, the courts have repeatedly said, don't interfere too much in that decision not to confirm an appointment. So I think that encompasses it. That says, listen, if you're an employee, you're gonna, the effort now needs to come from you during that first period. And even if you're a long-term employee, you need to buy into the company culture. And look, if it's a good culture, obviously you can have bad
not talking about
cultures as
toxic
well.
work. Yeah.
No. So no, you don't have to fit into toxic. But if the company is putting in genuine efforts to create a harmonious working environment, and you're coming in there and you're the bull in the china shop, you might find yourself at the end of an incapacity. So very bold to recognize it. I don't want to be the first one to argue it, but I would love to see how it runs through to the Labour Court.
Any employers in the comments would like to be our guinea pig for this? Let's see how it goes. No, listen, guys. If there are any viewers in the comments, please let us know your thoughts on incompatibility in the workplace. Someone doesn't fit in. It could be for various reasons. And I'm just thinking, while Jean was now saying, America, Trump is doubling down on the woke culture and cancel culture and canceling cancel culture, whereas we are obviously trying to still build up to that point where we're accommodating mental health in the workplace, but then we have the flip side of it, incompatibility for whatever reasons, cultural fits and so forth. And I kind of like the fact that the courts say, listen, this is between the employer and the employee. It's not for the courts necessarily to decide whether that person fits into the workplace or not. That is an intrinsic, very personal thing. And I mean, for employers who want to create a healthy workplace that has a great company culture, organizational culture, I think it's important to handpick the employees. But on the flip side, protect them by following the correct procedures, or at least setting a policy out in writing that the employers agree to that is in compliance with Schedule 8 with the law on how to deal with these kinds of things. Jean-Ray, I'm going to throw this next one to Daniel, but you were touching on probation and almost poor work performance there. That now requires training and support measures. So I'm sure a lot of employers would actually like to know how much effort should they put in before terminating? What is this reasonable time period?
Yeah, so when I started engaging with this particular point or this particular aspect and this aspect of reasonableness, I think it's always a word that, depending on the situation, it kind of sends a bit of a shiver down the back, because how reasonable is reasonable, and what's your reasonable and my reasonable is sometimes two different things, So, but I think if we maybe just pull it back, the reasonable has to be in line with the situation. For instance, if you're dealing with an employee who's maybe not got such a highly skilled or a professional job that they have to do, there's obviously a certain amount of training and expertise and guidance that needs to be given. And I think it will be fairly easy to ascertain whether or not they're going to reach that required level or not. And then also judge, how much training is reasonable or how much guidance is reasonable in those circumstances. Whereas if you're dealing with a more technical or more expertise kind of role, I think that's something that obviously is a bit different in the circumstances. But I think reasonable, when we're looking at it through the lens of this new code, and also when we look at reasonable through the lens of labor relations in South Africa, it's give an opportunity, give the tools, give the necessary, guidance, and allow an opportunity. I think far too often we see that the training's given, or the skills are given, or there's guidance given, but it's too short. Sometimes it's I'm going to give you a few days to kind of crack this, and if you don't, it's the end of the line. So I think reasonableness it's a multifaceted thing, but it's something that it will be situational, and I think sometimes, unfortunately, there are employers that have been in that situation where they think, I've given a chance, I've given another chance. I've been more than reasonable now, only to end up at the CCMA to be told, no, actually you weren't reasonable enough, kind of thing, So I think the bottom line is, make sure that you give all the necessary tools that you can possibly give, and allow some time. And if you've done that, I think to a large extent you would have covered that basis of reasonableness in that situation. Yeah.
So, something that sorry, carry on.
It's a tricky one. I know that we struggle with this thing of reasonableness, because it's highly situational dependent, and it's something that obviously each workplace is unique, So the amount of training that one person might need to reach the standard, as opposed to the amount of training someone else might need to reach a standard in the same position, might be two very different things.
So earlier I mentioned the over-encompassing caveat of it depends on the circumstances and facts. I want to try to stay away from that, Daniel. So gun to the head, what would you say is a reasonable period of time? It doesn't matter. We're talking about incompatibility, poor performance probation. If you had to slap at a certain time on it, what would be a safe time period for employers?
Yeah, it's really difficult to answer this question without saying it depends, but
it depends. Caveats there. Carry on.
No, look, I think a few weeks is sufficient time. I think if you give 2 to 3 weeks, whether it be an issue of expertise, whether it be a compatibility issue, whether it be a work performance issue, I think after 2-3 weeks, after giving training or giving guidance, or even just this issue of incompatibility, if you may be having discussions with the employee and things like that, you would be in a safe place to see whether or not this is going to work or not.
100% no. So the wording that comes to my mind from the labor court judgments that I read is, has the employer exhausted all the necessary steps? Have they been able to prove that they've taken the reasonable steps in providing this person with a platform of support that they needed to perform at the standard that is required? And that, as you say, will differ from job to job depending on what the nature of their responsibilities and duties are. I just want to deal with some of the comments that are coming through, so thank you for that. We have a comment here. As an industrial psychologist, I think that the validity of a person, culture, fit will be hard to prove, and period there will have to be a period for an individual to get accustomed and immerse in the culture. I see over there that we've got the comment on the screen over there. Thank you very much for the support there. Comments, guys?
Yeah, I think... was it yourself or Jandre mentioned when answering this question, slippery slope? I have to totally agree with it. And I think, like Jandre mentioned, we don't want to be the first one to have to arbitrate one of those disputes and go to the court, because
I think we should dive in.
Geez, I think it's really going to be a very unique situation. And, like the comment rightfully says, one person's fit and another person's fit, and the timelines and things to adapt to that fit are going to be two very different things. And finding a black and white kind of way of doing that's going to be tough.
So we have another comment regarding... sorry,
just on that as well. Firstly, a shout out to Marco Pretorius. He's the industrial psychologist student who won the CEO award at Koffie's last year. So I'm glad we're still bringing back all the old candidates. Look, Marco, I hear entirely what you're saying, and I think, and I'm speaking for CEO internally, that's why we focus so much on onboarding as well during that onboarding process, so individuals know, listen, this is the type of culture we try and create here. So I agree in totality, it is going to take a while, but I think if you, especially in professional setups, if you have a proper onboarding and the culture is made clear, and what is expected, and those expectations are carried over to new employees, you might be able to shorten that period by quite a bit.
I think just to make it a little more personal, maybe Genre, you can give a tip or two on what we are doing for our onboarding. So I mean, all of our new officials are being subjected sounds like I'm experimenting on them. They're being offered a psychological testing, through Clifton Strengths, particularly to build that team dynamic. Maybe you can just elaborate on that. Give an employer support too.
Yeah, no, definitely. Let's pundit Carla Pretorius a little bit with her Clifton Strengths. Yeah, look, it's a tool that we use to obviously identify individual strengths and how they fit into the culture of the organization. So it's something that CEO has bought into, and we try and be a strength-based organization. Just with the onboarding as well, there's a section, a meet section between, let's say, myself and Daniel Cole. You are also involved. Our executive director Annelien Breedt's also involved to get that personal relationship between officials that are spread around the country. And we have a lot of organizations that still have remote working. Yes, you said Trump's calling everyone back, but South Africa's dynamics are different. I don't think we have such a strong woke per se culture. We have a strong South African based culture. And that's something I think all of us share. So we try and bring people into that. And I hate to say family and buzzwords and stuff like that, but you bring them into the community of the organization by saying, listen, these are the things that we do. These are the initiatives that we run. This is how we communicate with each other. So that should always assist. And we're getting extremely good feedback internally from our officials due to this process. So yeah, those are my tips. Make sure that when a new employee is there and he starts, he understands what the actual culture is, because having him guess the culture is never going to work.
I think the development of company culture has become so important. If I look at all the big organizations nationally and internationally, it's a huge focal point for them of how employees fit into their culture. So thank you so much for the comments there. So before I go to the next question, I just want to get through a few comments over here. We have one comment on a closed shop agreement. We'll deal with that upcoming now under unprotected strikes and industrial action. So I'll just move on from there. We will get to you though, so please stay tuned. Our next question over here is, how does the internal grievance procedure fit into incompatibility? It's on the screen there for you guys. Daniel?
Look, I think that's quite a big question, and it depends on the situation. I think the grievance, it depends on whether it's obviously the nature of the grievance in terms of how it's directed at a specific person or a specific practice and things like that as well, because I'm assuming the questions may be aimed from the point of view of that person who's feeling or is maybe seen as incompatible, is now, kind of having this grievance or stemming from that as well. So I think we see that's, again, maybe potentially one of those gray areas where this incompatibility aspect is going to be judged, because, let's put it in a practical scenario that might manifest itself in the workplace. You might have a director or a senior manager or someone who's maybe just very difficult to get along with, or maybe just speaks to you in a terrible way, or is belittling or demeaning or something like that. And because as a result of it, you maybe lodge a grievance, they say you're incompatible because you're not fitting into the culture and the way of doing things. So I think there's going to be, it's actually a very good question now as we're talking about it, it's going to be a big interplay between your grievance procedure, for instance, and potential incompatibility there. Because the manager might see it as you're just incompatible, and the employee will see it as, no, you're just rude, and, we can't work like this kind of thing. So I think there's ground there for quite a big interplay between the two.
Yeah, no, so I think just my 2 cents on the internal grievance procedure for employers, follow the same grievance structure that you would, regardless of what the grievance is, and then obviously investigate it accordingly and subjectively to the nature of that grievance. But apply the same duty of care and responsibility investigating something like harassment in the workplace versus incompatibility. And maybe those two are even correlated, because me feeling incompatible in this work environment might lead to also me feeling bullied or harassed within this work environment. So you need to, as an employer, have an open mind and deal with these issues head on by following the policies and procedures in your place in your workplace. Last comment, or just to get up to date before we get onto the next segment over there. Will the code of conduct suffice to explain co-culture, or should companies be providing a document explaining their culture? Would this assist in explaining or showing incompatibility regarding a cultural fit? Chandra?
Yeah, well, back to the onboarding, Lynn, it's a very good question, but can I really capture culture in a document? That's difficult. I'm not saying you can't do it like that. You can obviously build on an organization's values and what is their mission, and what are their cultural aspirations. If you look at CEO's culture, we strive to be the voice for employers. We strive to to be the answer for employers within the labor sphere. We try and be professional. We try and exude respect to not just counterparties, to employees, to commissioners, to all stakeholders. So you can capture that in a cultural fit, but I think it might be, especially if you have remote employees or different branches from, let's say, a central hub, to say, well, listen, this is our culture. We want to create a environment of mental well-being and stuff like that. So I think that personal touch will probably be your better option. But yes, a document to say, listen, this is our culture, this is our vision, this is our mission. It'll always suffice.
I think, Daniel, you wrote an article about this recently, unwritten but not unknown. And I know you were talking about specifically company practices and policies and procedures. But in my mind, having your company culture reduced to writing is actually setting the aspirations and the ideals of what you should be. But company culture, in fact, is actually what it is currently, based on the people that you're hiring being culture consumers, absorbing the culture as someone new in the company, adapting to the unwritten policies and procedures of how we do something. Maybe you have that American culture where we all, talk a bit of trash at the water cooler during our coffee break. But also, ideally, from an employer's perspective, you want to empower your employees to become culture creators that align with the ideals and the aspirations that you set. By us saying we want to be an inclusive and diverse culture doesn't necessarily mean that we are currently. That's what you are aspiring to be. But in order to achieve that, you need your management in place who are setting those sort of goals and aspirations and also practicing them, letting that filter down to the rest of your employees who then see those examples and then follow them through. And that is more or less of how you would do it. So I think it's good to write it down and have it as an aspirational ideal, but you also need to be accountable and check whether your ideals and aspirations are actually being aligned by what is currently being done within the company. All right, we have another comment over here. Workplace incompatibility can go beyond cultural fit and also include misalignment with a manager's style. I honestly struggle to see how procedure will work with regard to this issue, as incompatibility is likely to stem from a particular manager or direct supervisor. Comments, Daniel?
Yeah, I think it's that whole situation that I've actually just described. I think it's you mentioned culture as well. Sometimes it's just we misunderstand each other, and that's not necessarily an incompatibility issue. It's just I think TD used the word there, misalignment, and I think that's also where it becomes important to, if we rewind all the way back to the start of the
I know what you're going to say.
open dialogue and
genuine dialogue.
Genuine dialogue, there we go. I think genuine dialogue can go a long way in these kinds of situations, but to clear up misalignments. But I mean, we can also not shy away from the fact that there are just people don't get along, irrespective of how much you try and align yourself to the way they think or the way they do things, or in as much as you try and get them on board with the company culture, organizational culture. There are just times when people don't align, and it's not necessarily your fault or their fault. It's just, things just don't align sometimes. So yeah, good comment from CD there.
Thank you very much. Keep the comments coming, guys. We really appreciate the engagement, and we'll definitely be putting these comments forward as the public comments to the Minister of Employment and Labour. I just have a few more questions for you, Daniel and Jandre, before we get some quick-fire controversial questions. Should an employer be able to dismiss an employee for being in jail? Now, before you answer, I know there was a recent case law on this that didn't swing in the way of the employer, but this is now becoming more formalized in the draft code. Comments, Jandre?
Yeah, look, it remains operational. What am I sitting with? Is it is it a long-term incarceration? Is it a short-term incarceration? And that becomes difficult because people get 15-year sentences and they're out in 6. That type of scenario. But look, it should be a fair operational question on my part. If it's a 3-month thing, and I would deal with it exactly the same as a temporary incapacity. So the same as a medical incapacity, an individual's off for 3 months due to medical reasons. The question remains the same. Can I accommodate that temporary incapacity operationally? So if it is my director, if it's my financial manager, I probably can't wait for 3 months to fill that position. If it is a blue collar worker, maybe, maybe I can accommodate them for that period. I think the can I terminate, can't I terminate is the one side of the question. The other side of the question is, how do I have a procedure with this individual that is currently incarcerated?
Jails have visiting rights.
Well, yeah, true. You can arrange, and I've been involved many years ago in a situation like that where you actually go and incapacitate an individual. I think we need to look at the code, and the code is trying to push one, employee rights, but also fair business rights. So they recognize the fact that a company has to survive, and they have to proceed. So again, look at each one of the scenarios, but if it's operationally not viable, strongly believe I strongly believe we will need to be able to terminate if it is really going to have a extreme operational impact.
So 2 questions that arise from that, and I'll read a comment that we just received on it for the third thing there. First question, just for clarity, Jean-Ray, as an employer, if I have one of my employees incarcerated or put in jail, what procedure should I follow? Is it incapacity or?
I would advise a incapacity process, because that's exactly what it is. Today you had the capacity to fulfill your duties, and tomorrow you're incarcerated. You no longer have that capacity to perform. Obviously, if the reason he is incarcerated is due to theft at my place of employment, it could go the misconduct route. But if it's irrelevant to it, it is going to be incapacity, according to me. That is my opinion. That's how we've dealt with it in past.
No Wi-Fi in jail? Can't perform the work from there? Just kidding. Listen, so now we have a comment over here from Adrian Bushy van Rensburg. Will the type of offense also play a role when it comes to obviously being incarcerated? And my question that pops up with that is, subjectively to an employer, I mean, you're employing an ex-convict, or let's say a current convicted person. How do employers deal with that? Because now we obviously have very staunch anti-discrimination laws, and difference between discriminating and differentiating, sure, but I'm sure a lot of employers will feel a bit conflicted regarding this. You commit an offense, you have someone employed, it's not necessarily work related. Let's say they are in for a short period of time. How should they feel about that?
What is operationally required? But Daniel, yours?
Yeah, look, I think it is obviously a tricky one, because there's also been recent case law that's come out about, in terms of someone's criminal record, and how relevant is that to that particular job that they're doing or applying for, kind of thing, So it's a bit of a difficult one, in the sense of, obviously, like Jean-Ray mentioned, he used the example of if the guy or if the person has stolen from the business and they're sitting in jail as a result of that, that's kind of one thing. It's a different thing if maybe it's totally unrelated, and obviously needs to be looked at in the view of, is it fair or is it relevant to that particular job or role that they're performing.
So just a comment over here that we received. The incapacity clause 10 and 11 of the old code includes many permutations, long-term incapacity, incompatibility, incarcerated employees, or those with expired work contracts or other non-compliance. So just more of a comment to build onto what we were saying over there. I don't know if you guys have any comments on that, or maybe covered it.
Look, I think what's going to be quite prevalent with individuals returning to let's say to work is probably going to be that incompatibility. You have an individual charged and convicted of a serious misconduct, and now he's entering back into that workplace, and you're sitting with a scenario where the other employees are maybe scared. So that might also play into that incompatibility as well.
That's an interesting point. Employer has the vicarious duty to provide a safe working environment for all employees. Now, you maybe have a violent offender who isn't dismissed back at work. I think, an employer should obviously take those other employees into consideration, maybe have a meeting, see how people feel or where they sit on it, maybe anonymous poll to see, what's going on. Would that, in essence, be enough grounds to file or to lay a grievance for incompatibility or incapacity? Let's say majority of the employees don't want this ex-con in the workplace. What does an employer do?
The answer to that question is to be seen. That'll probably be where you start, but it's I believe it. Look, this is going to be interesting, and I can promise you now, in the coming years, this incompatibility thing is going to become the topic of many discussions. But yeah, it is to be seen. I would advise that you follow that proper grievance process, or that that it's almost like a mutual interest dispute. Listen, we cannot perform our duties due to a fear of this individual. So many fermentations. Let me not bog us down to one just yet.
100%. Okay, guys, moving on. We have a question pertaining to closed shop agreements, but before we get to that, I just want to unpack unprotected strikes and industrial actions quickly. So the new procedure for handling these unprotected strikes, does this give employers more power? Daniel, you're in collective bargaining?
Yeah, I had a feeling this one would come my way. So look,
Of course.
yeah. So look, in terms of if we look at the new draft code as opposed to the old code, there's not too much difference. There are one or two insertions regarding, whether the employees reject the ultimatum and things like that. But I think for me, what's a bit of a worrying factor, and it's maybe a personal opinion, but in the new draft, it talks about, when you can assess the seriousness of contravention or of the unprotected strike, and it talks about things like the legitimacy of the striker's demands, the duration and timing of the strike and things like that. And for me, that I don't know, it opens the door a little bit on this particular aspect, especially when it comes to an unprotected strike, because when does an unprotected strike become not so serious, and when is it a serious one? And that's always been the kind of the starting point is an unprotected strike generally results in a dismissal. Now, when you add these permutations to it in terms of, the legitimacy of the striker's demands and things like that, it opens the door, in my opinion, in terms of dismissals related to unprotected strikes. We also have a tendency we tend to romanticize strikes a little bit in South Africa because we're used to them. We're used to the fact that they can become violent, and it becomes almost, I don't want to say the norm, but it happens more often than not that they do sometimes become violent, and they result in a lot of damage and things like that. So when you start introducing these factors that need to be assessed as well, for me it's a bit of a worrying factor, because I think generally we need to have a bit of it depends mentality sometimes when dismissing. But when a strike becomes unprotected, because there are already mechanisms in the legislation to have strikes protected, and the various steps and procedures that need to be followed to ensure it is a protected strike, it is a bit worrying for me in terms of these new factors that need to be considered that weren't there in the past.
100%. Sorry, I'm just keeping it.
No,
please.
To answer the question as to whether it gives employers more power or not, I don't think it does, to be quite honest.
So just for our viewership basis over here, we are a little over time. We will be wrapping up in the next few minutes. So thank you for sticking with us. I hope you guys have found it informative so far. Please keep the comments going, even if it's after the fact, we will get to them. The comment in the closed shop agreement is not really relevant to this discussion, but I will also personally respond to it on the comment section over there for you. So we'll get to that. Moving on, should employers be required to consult the trade unions before disciplining union members? The current stance is yes. That obviously now continues with the code. Any comments?
Yeah, it does. So it does continue, obviously. I think so. I think if we're talking about it from the point of view of trying to mitigate damage, if we're trying to mitigate the furtherance or the perpetuation of the strike and things like that, I think, yes, it's definitely a good thing. And I think also, remember, a lot of the times parties continue to have a relationship after the strike as well. So in terms of maintaining those relationships and ensuring they don't maybe break down to points that just become intolerable for both sides, I think, yes, by all means.
Great. We have a comment over here, just goes back to incapacity and incompatibility. If an employee was to be involved in a brutal engagement outside of work, nothing medical, but it leads to a month away from work because of sustained injuries, incapacity? Question mark. Chandra?
Yes, definitely incapacity, temporary incapacity. Again, you're going to have a look at the operational requirements of that specific position. But no, temporary incapacity, UI 19, there you go.
Yeah, I mean, during that investigation, you'll determine whether the incapacity is temporary or permanent nature. Are there any ways around it to mitigate it, alternative jobs that they could do in the meantime? And then the employer must obviously use the cards available to them. All right, guys, I'm going to move on just to some yes or no questions. I want to play a game with you two as we're wrapping up over here. So you can only answer yes, no, or no comment. All right, you can plead the fifth. All right, genre, first one. Is the draft code making dismissals easier or harder?
I believe clearer, but no.
Yes, no only, or no comment?
No.
Okay. Daniel, does the code strike the right balance between business efficiency and workers' rights?
I'm going to be bold and say yes.
Good. With the rise of AI automation, should dismissal laws be more flexible to accommodate job losses? Chandra?
Yes.
Daniel, are employees too protected in South Africa or not protected enough? You can choose.
Oh, that's an unfair question to someone at an employer's organization.
Bias aside, no comment?
Now, I would say there's times when there's too much protection, so yes.
Okay. Chandra, is incompatibility just an excuse for getting rid of employees who do not fit into the company culture?
No. It shouldn't be. No.
Okay. We talk for the greater good here, so we're assuming that they're doing the right thing. Daniel, should employees dismissed for misconduct get severance pay? This goes back to the old Labor Relations Act.
Yeah, no, this is a no.
Operationally, no. And Jean-Ray, last quick fire here. Do labor laws in SA discourage business growth and hiring?
No, should get it sometimes.
You can say, I'll allow sometimes.
Sometimes.
100%.
Sometimes.
Guys,
But this is a step in a right. This is a step in the right direction. I will say that. I will give the Department of Labor and the Minister their kudos. It's a step in the right direction.
Well, it sounds like we have a little to unpack on our new podcast that we're going to unveil. You heard it here first. All right, last comment before we close off, guys. Does the incompatibility section not open an organization up to violate the Employment Equity Act, especially in male or female dominated industries? Last question.
Daniel, do you want the minefield or shall I?
I'm not sure. I'm not sure if it's a yes, no, or no comment. But if we're going to go yes, no, or no comment, I'm going to say yes. I think so.
And there we go. You heard it all here, guys. Jean-Ray, Daniel, thank you so much for your time. For all our viewers tuning in, thank you very much. I know we have gone a little over, but we had a lot to unpack, and I had fun in doing it. So we look forward to seeing you guys again. And from CEO and CEO Academy, thank you for tuning in. See you guys next time.